Good morning. How are you doing? Good. So, did a few people register at least? Oh, wonderful. Yeah. Yeah. I don't know what the heck is the problem with people. 1.5 million lawyers, and they don't want to join a free. Join करके टीवी देख लो, पर शुरू तो करो एटलीस्ट join पेड. But today the courts are closed today, right? Or something, I heard. Hmm. Hmm. NPS had a. Sorry, I have to take this call. Hey, Arvind, how are you doing? You heard the great news. No. We're sending out a letter to everyone, but I think the courts will overturn it. This is just stupid beyond belief. So I wouldn't worry about it because the American companies, yeah, it's the American companies that consume the majority of the quota, right? So Indian companies तो just बदनाम होती हैं, but in majority is used by the top 20 American tech companies, Googles and Microsofts of the world. Yeah. So I think it's just drama. You know, he likes doing drama, right? So he's figured out that the way to get 1 million hits on his Instagram account is to do something with India, right? Because India is the 51st state of United States anyways, right? With 1.4 billion people. So this is just that drama. And it's a FU to Modi because Modi is not returning his phone call. Yeah. I wouldn't. Yeah. Right. But the delegation doesn't know about this. This is the gundas in White House doing this. Yeah. Yeah, yeah. But karna hi hai bomb, so then might as well, right? Yeah. Don't worry about it. We're sending out a special alert to you shortly. It has all the details.
Good morning, Lordship.
Hello, how are you doing?
Good morning, Lordship. How are you?
Good morning.
Very good. Um, Justice Sikri, how are you doing? Satwinder, how are you?
Very fine, sir. How are you?
Very good. Thank you for joining us.
Hey, you're on mute. Lordship,
Yeah. Yes.
Yes.
Satwinder, you're on mute.
How are you, sir? I think, what's the time in LA now?
LA is 10, but for some reason I had to come to New York
Okay.
for a Clinton event that happens every year, the fourth week, Clinton Global Initiative. But since you guys had picked the date, I said no problem. New York is one, but no issues.
Yeah. My son is also in New York. He's in White
Oh, he
case.
I see. Wonderful. Very good. So we have over 100. Some people have registered, but we're live on Facebook, YouTube, and LinkedIn, Shanti?
Yes, sir.
Okay. So we'll have people joining us there. So all good. We have wonderful panel and wonderful.
Good morning.
You see,
Hello, Mr. Chawla. How are you doing?
Hi, sir. Good morning. Good morning, Sir Sigal.
Sat
Sir
Sri
Sigal, my
Akal.
lords. Sorry, I have a very bad
okay,
throat somehow.
Chuksab, Justice
How-
Sikri and Mr. Chandok are like my big brothers and mentors. So
Right.
I think I've always get the blessings as a younger brother. So when I told them that, okay, you are nominating me as a president, I said, I can't start my first webinar without their presence.
Right.
So
I got bad news for you, Satwinder. Now you are an elder statesman, and now you have to mentor other people and take care of the 50,000 lawyers of Delhi. You graduated.
yes, no, I think not. I think there is a different perspective of journey. मेरे से ज़्यादा शायद NPS मेरे बारे में ज़्यादा लिख सकते हैं आप.
Yeah. Well, he can
And
be
I
president
also
after you.
compliment the way you have moved from Chandigarh and set up such a huge practice in US with almost how many offices now you have now, sir? To LLP?
23.
23 offices. Yeah.
Excellent. Excellent.
I got very lucky. I came to US when the computers happened, and then we just stuck to technology. And I got these big Indian companies as clients when they were tiny, Satyam at 500 and so on and so forth. And then all I had to do is not lose them and continue servicing them. Then internet happened, then India liberalized, then Indian software engineers coming here, then Y2K happened, dot-com boom and bust happened, and these top 500 Indian companies are all in the US now. And so you do their corporate work, tax, litigation, immigration, real estate, a little bit criminal when they get into trouble. But yeah, it's the wind's been behind and nothing special. And we're lucky that we got good employees that have been with us for 5, 10, 15, 20, 25 years. So my job was to let the good employees service the good clients and don't interfere too much. That's it.
I think
Okay,
that's
so
what managerial skills require.
yes, difficult at times, but yeah.
I think, are we live? I think.
Yes,
Sorry.
we are.
Yeah,
So good. So we'll start. I don't know, Satwinder, if some of the other speakers are there, but we'll start.
Chandok, I think
They'll
Mr.
join.
Chandok is not here. I think he'll join.
Okay.
I'll speak to him in the meantime.
Okay. Good morning, everyone. Thank you for joining us on a beautiful day, September 20th. We have a very interesting topic, and we have a superb list of speakers that will talk about the various topics that we're going to talk about, how to enrich academically, ethically, and monetarily. I will share with you that I only wanted to talk about money and how to make more money, but the wonderful lawyers of Delhi say that's not a very Indian thing to do, to talk about money. So we have to talk about academics and ethics, which we will. But I think we started Indian Lawyers Association in 2018. We felt that there wasn't a common all practice areas nationwide industry body for lawyers. And of the 100 people that got us independence, maybe 75 were lawyers, Gandhi, Nehru, Jinnah, and Sardar Patel, and on and on. But when independence happened, 350 million people were let out of prison. But the 200,000 lawyers, for whatever reason, decided to stay back in prison and locked the doors and threw the key. Now there's 1.5 million lawyers in India, and we feel everybody is independent in India, 1.4 billion, except for the 1.5 million lawyers. We cannot advertise, we cannot have a website, we cannot have a booth at a conference. We can't take matters on a contingency basis. If we want to teach, we have to surrender our law license. So I don't know what happened to Article 19, that there shall be no restraint on trade. So we'll talk about all of that. And, the big issue facing 1.4 billion people is, for hundreds and hundreds of years, India was the richest country in the planet, at least till 1750. If you look back into history, every year, India had about 25% of the world's population, and Indians were always fair and always had 25% of the world GDP, somewhere between 24 to 28, 29%. And then the decline started in 1750, and we dropped to 2.5% of world GDP. And finally, the climb back up is happening. And now we're 5% of the world GDP, but we're 17% of the world's population, and we're 12% behind. And if the world GDP is 100 trillion, India is 12 trillion behind. That means $1 trillion a month is being stolen from us, or we're letting it be stolen. So the climb back has happened. One day we will have 17% of the world GDP. 20 years from now, 50, 100, 200, 300, 1 year it'll happen. The important issue for us is that lawyers are supposed to be playing a very integral part in a democracy. So what is it that we can do? We got economic freedom in 47 or 91, political freedom in 47. And I feel that the next freedom, the next revolution must come from us lawyers. We have to fix India. We have to get into the driver's bus seat and not be a passenger and not be in prison. So for us to get stronger is why we started Indian Lawyers Association. We have a goal to be in 400 cities, all the 400 cities in India with a population over 1 lakh. We are in 100 cities right now, some active, some not active. We're constantly fixing that. So what role can lawyers play for India to become a first world nation is basically our topic, and we'll talk about all of that today. And I want to take this opportunity to introduce Mr. Satwinder Singh. He has been appointed our next president of Indian Lawyers Association, New Delhi. Satwinder has been in practice for 20 years, and he is a founder of ACOM Legal. He's a corporate and M&A specialist, advising on private equity, mergers and acquisitions, and insolvency. Satwinder, congratulations.
Yeah, thank you. Thank you, sir. Thank you.
Welcome as president of ILA New Delhi. What's your plan?
No, the plans are, I think, whatever you see aims and objectives, you have sent it. I'm trying, I'll see that, okay, to the best of my ability, I should take it. And the most important thing is the academic knowledge which we have to impart. We should continue with this, and at least one program, we should have a good program on the relevant subjects for all the lawyers, so that they be continuously enriched with their legal education process. That's the important thing. And that will get involved for the mega events also, interesting, with the blessings of all.
Delhi is the largest city in the world now, with 38 million people. And it's so spread out that we actually have a ILA Gurgaon and an ILA Noida to make your life easier. So you just worry about the main capital city. But it's spread out enough that you should do events in North Delhi and South and East and West, so nobody's left out. The only request we have of you is that third Thursday of every month, every ILA chapter is tasked to do an event. So whether it's at 3 people having coffee at CCD, or going to park, or going to India Gate, or meeting outside a court, or outside a mandir or a gurdwara, or in a courthouse, or in front of a judge, or at your house, or doing a Diwali party, whatever it is, please do something on the third Thursday of every month.
Yes. Okay.
Thank you. All right, so we will start.
And NPS, why not you introduce the speakers for the day, and Justice Sikri is there. I think Shanti, the
Yes.
others are finding little difficulty. I'll just make it to join through their laptops. Maybe the link is not.
No, yes. No, I've also got few messages, but they're able to join. I think there are many people who have joined. You can speak to Mr. Chandiop once. Satvinder sir, you can just try him. I tried his number.
Actually, Mr. Satvinder, like Mr. Chandivook joined the meeting, but like he is in participants. He need to join as a presenter.
Oh, I see. So you'll have to send him a different link, Shanti. You can
Yeah, I have sent it today.
Yeah, Satvinder ji will
yeah.
speak to you. Okay, right. We'll proceed ahead. We already have our chief guest, Justice Sikri here. Thank you, Mr. Chuk, for having us here. Despite being in California and running a law firm there, 23 offices, 500 lawyers with you, and then still thinking, sorry, I'm not able to speak at my normal pitch because of a very bad throat infection. But still, I'll do my level best, as I've always learned from my mentors, including our chief guest, Justice Sikri, who I've always been considering as mentor. In fact, all Delhi youngsters would feel lucky to have Justice Sikri with us always. Justice Sikri, just to share with everyone, and Mr. Chok, I don't know if you have the good fortune of earlier interacting with Justice Sikri or not, but let me tell you that there is a saying that it is easy to reach at top. It's easy. I mean, one can still reach at top, but it's almost impossible to always remain at top. But there are exceptions, and exceptions. One such exception is Justice Sikri. Justice Sikri did his law from Delhi. Before that, did his graduation from SRCC, topper law from Delhi University, topper masters in law, again a topper, gold medalist. Then all through he's been, and in fact, the more I know about Honorable Justice Sikri and more I read about him, then I got to know for the first time today in my career of 20 years that Honorable Justice Sikri was also once the Vice President of Delhi High Court Bar Association, and thereafter became senior advocate, became High Court judge, Chief Justice of Punjab Haryana High Court, then became a judge of Supreme Court, now international judge in Singapore International Commercial Court. Most importantly, Mr. Chok and all the participants of at least Delhi would know. And Mr. Chok, just to share, that he's an amazing human being. You just go to Justice Sikri and he's a problem solver. He'll have a solution to an impossible problem in the world, including a case which nobody of us can forget, where he was handling a case of a medical student in 4th year, got to know that he got admitted wrongly. And Mr. Chok in 4th year, Justice Sikri then decided that instead of spoiling that boy's career, let him become a doctor, and then later become an extremely great doctor, medical doctor, but he'll have to serve for 1 or 2 years in Tihar jail. So instead of ruining his career, that's the approach, that's the mindset a lawyer, a professor like Justice Sikri can take, and that's how we thought that we'll request Justice Sikri to speak on such an important topic, which is really interesting. And when I was informed that Mr. Chok, who is the founder of ILA, has given this idea to do this program, how can lawyers be enriched monetarily? And then Satvinder sir thought that we should expand it and not only talk about monetarily. In fact, monetary is secondary. This is what I have always learned from him, that choices are two. I can say this in Hindi as well, I'm sure. Choices are two. We can either follow Lakshmi or Saraswati. If we follow Lakshmi in the beginning, then I'm sure we'll be failing very soon. But if we are able to follow Saraswati, which all my mentors, Mr. Chandiop, Justice Sikri, follow every day, including Mr. Chok, that if we follow Saraswati every day, if we follow Saraswati every day, then Lakshmi will automatically follow. And that's how we changed the topic for the day. And Mr. Chuk appreciated that instead of only talking on how we can enrich lawyers monetarily, let's first talk about how we can enrich lawyers academically, ethically, and monetarily. And that's how we thought who better chief guest we can have than Justice Sikri to speak on these subjects, particularly academically, because Justice Sikri has also taught in various institutions. I think we also have now Mr. A.S. Chandyok. I think I heard him. I am unable to see him. Mr. Chandyok, if you are here, I would request if you can switch on your video. And till then, friends, keeping this program on a Friday. It was me who insisted that please have it on a Saturday. Lawyers are free, at least from court. But I forgot, Mr. Chuk, that I told you that district courts are working. And Mr. Hariharan is a criminal lawyer. He's a criminal lawyer. He's a senior advocate, president of the Delhi High Court Bar Association. We'll give his brief introduction once he joins. Mr. Satvinder Singh, as we all know, is Central Council, past Central Council member of Institute of Company Secretaries, founder of Econ Legal. He was also member of Appellate Tribunal for CACS CWA Appellate Authority. And we'll also have Dr. Sanjeev Gamawat. We'll also introduce him once he joins. I think now we can request Justice Sikri. He's been very patiently waiting. He has a busy day always. It's very, very difficult to get time from Justice Sikri because he has so many of arbitrations from morning to evening. Would request Justice Sikri to please share his chief guest address and enlighten us as always.
Thank you, Mr. Chawla. So I'll start with the first question with Justice Sikri. Justice Sikri, India wants to become a first world nation by 2047 and want to ask you what role lawyers can play. But before that, I want to ask you that if you look at the judicial system of India world ranking, it's not the best, and India's legal system faces many challenges, and you know it better than anyone else. Huge backlogs, 60 million pending cases, lack of access of justice to the poor, rural, chronic judicial vacancies, weak court infrastructure, corruption, criminal justice system, where bail hearings are taking years. How did we get here, Mr. Justice Sikri, and what's the solution?
I think, okay, Mr. Chuk, you have, in this question, there are so many subsets, sub-questions which you have asked. So let me take all these facets one by one. But before that, I should say thanks to everybody, including you, Mr. Satvinder, and Mr. Chawla, for inviting me on this webinar. And Mr. Chuk, as I have now come to know with the introduction which you have given about yourself and the manner in which you shifted to America and how you have set up your practice there and how it has blossomed, really, I mean, it's admirable. And we hope that more and more Indians, many have achieved such feats in America and more achieve, notwithstanding what is happening at present in America. But Mr. Chawla, thanks for your generous introduction, which was not needed anyway. But now coming to this question, I mean, you see, first of all, let us see how we perceive the role of lawyers at present and how it has transformed from time to time. And along with that, I will, I think, take the other issues which you have mentioned about the our legal system, which is suffering from so many maladies, which you pointed out. And so, first of all, let us see, and you yourself rightly mentioned what was India in 1947. At that time, and from 25 to 27, 28% GDP of the world to it was less than 1% in 1947 when we became independent. And it was also a time, at that time, we also knew that we have suffered almost for 1,000 years, invaders coming from outside and invading India and ruling. But at least 250 years, British rule was also there. And it is primarily during that period that all these, as far as economic decay is concerned, that happened because of various reasons, which we need not discuss here. But what I'm trying to emphasize is that in such a scenario where poverty was rampant at that time, a normal person, and it was not only poverty, illiteracy also was really at a very, very high rate. People were illiterate, not many were literate, etc. And we wanted, or at that time, I won't say we, in the sense the generation of that time or the leaders of that time, I was not even born. They really wanted to see, and all these you can see at the time of independence, the speeches, etc., which were given by the great leaders, and about it, that what India should be in future, and which was then captured at that time when our constitution was brought in 1950, 26 January 1950. And why I'm emphasizing on, because constitution and lawyers are very much connected, and role of lawyers is very much connected with these constitutional ethos. We, of course, try to pick up good practices of various countries and their constitutions. And if I may say so, from the having focus on this present discussion, that what was the dream of the leaders at that time was incorporated and imbibed in the constitution as well, under various provisions, which talk of, and two main chapters, chapter 3 on fundamental rights and chapter 4 on directive principles of state policy, apart from many other chapters which are also very relevant for governance, what kind of governance, etc., should be there, the federal system, and all those things. But and that is captured even in the preamble also, that we wanted a nation. We wanted to give justice to the people, and justice, social, economic, political. That is what is captured in the preamble as well. And therefore, if you see the trajectory of Indian legal profession as well, and the way Supreme Court also functioned in initial years, it was that as far as courts are concerned, we are not the engines of growth of economy. That's a function which is left to the executive or the government to fulfill. But yes, the courts thought that there has to be a social justice to the marginalized section of the society, to the poor, to the those persons who are illiterate, and those who may be otherwise deprived of so many things in the life. And we have to therefore have the equality. Article 14 says so. And we gave those freedoms also, 7 freedoms in Article 19, Article 21 about the right to life, which was interpreted by the Supreme Court as right to live life with dignity. And dignity is one word on the basis of initially the profession also, yes, like in other countries here as well, but yeah, we could not go that way as America had gone by the time, as you mentioned about this, that earning and for that advertisement by the lawyers, etc. No, it was always perceived, and it is perceived even today, legal profession is a noble profession. We are here to serve the people. And the courts are here to serve the people, government is here to serve the people, and lawyers have to play their significant role in this mission which India has, which is in the constitutionalism, the ethos incorporated in the constitution. So therefore, from this angle, and the lawyer has always been perceived, if you see the speeches in 1950s, 60s, 70s given by great jurists and judges, etc., they all talk about it. And although it was there in 1780, 90 or early 19th century in America also, many jurists have said that the lawyers have to their first task is to serve the people. And yes, earning money is a secondary thing. So therefore, going by that, if we first thing which we talk about today's this thing, this webinar, as to what is the academic, about the ethical aspects. So this is to be kept in mind, and that still remains, because even when we are we have progressed a lot, no doubt about it. Economically, I am saying, in 1991, India ushered into liberalization and globalization, to which you also, Mr. Chup, alluded in your introductory remarks. And thereafter, India became a part of global world. And it changed the trajectory insofar as legal ecosystem is concerned. From a system which was catering only to indigenous Indian people and domesticated, but now we have opened our boundaries. So therefore, lawyers who are doing the cases, even commercial cases, etc., at that time, of course, not that there was no commercial cases, there were commercial disputes also over there. There were arbitration, there were intellectual property disputes, there were other property disputes, etc. All those commercial disputes, not that they have always been there from 1950 onward, but then the nature of these disputes changed. One thing which was done was that, look, in order to be a part of globalized world, because what we want at that time, and any country which is the need even today, and that is being discussed everywhere, is that there has to be a foreign direct investment in this country in order to have economic progress, which is very much essential. And when we talk of FDI, it is not only in the monetary terms. It can be technology which we take from the other countries, and say Maruti came, and Japanese companies, and even in the when we talk of motor vehicles, etc., many other companies which came. Today Apple is there manufacturing in India, and we talk about this Atmanirbhar Bharat, to which I will come to little later. But just to keep it short, what I'm trying to say is that and that was the demand of the world community. When the capital is coming, when the technology is coming from the other countries, and there are collaboration agreements which are entered into between the parties, they want Indian ecosystem also to be as robust as in other countries. So therefore, the convergence of laws which started taking place, we came out with the Arbitration and Conciliation Act, new act in 1996 on the this UNCITRAL model law, which was, as far as our intellectual property laws are concerned, they underwent a big haul in this Copyright Act. There were a lot of amendments came. Trademark Act, totally new act came in 2000. Patents also, lot of amendments were carried out to make it international compliant. And this thing has been happening thereafter. These are some of the examples I am giving. And the legal system, as far as litigation is concerned, it took a different, it transformed into a different, of a different nature altogether. In the sense, we have now, naturally disputes would arise. So these disputes now become international disputes, transnational disputes. And so therefore, legal profession in India has now to gear up to these challenges also, which it has been doing. We have, best of the lawyers, like You people come, Mr. Chuk, going from India has done so well, but people who are remain in India are also, and when I talk about legal committee, are doing so well in this. But then it requires, as well as when now I'm coming to the academic side of it, it requires, and along with that, okay, let me tell you another thing, which is again fast changing, this technology. So the way technology, particularly the artificial intelligence, it is creeping in, and how the legal profession is geared up to that, whether the technology is facilitator, but AI should also become facilitator, and it should not be something which replaces the lawyers, and which is a threat of in other professions also. But then these are the challenges which are faced in other countries, are now faced in India also. And therefore, now when we talk about 2047, so this is what the Indian government has said, that we want to be Viksit Bharat. So we are from underdeveloped country, we are developing country. We have developed a lot, but we still remain developing country. The problems of this poverty and illiteracy, etc., at least their 20-30% population still suffers. And in a 1.4 billion people, this means a lot. It may be equivalent to so many countries in Europe. So therefore, but on the one hand, this the role of the lawyers to do social justice remains, which I call that it is a call for Bharat. You have to give justice to this marginalized section of society. On the other hand, when it comes to Viksit Bharat, I call it here Bharat and India, where India is to come on the world map in legal, literacy and in legal profession. Then we have to, our lawyers have to compete with the lawyers in the other countries, and for that there has to be domain knowledge of all these subjects which are coming. We are having, disputes in space law today. There are bitcoins disputes, that all these technology related disputes which were not there earlier, and cyber disputes, cyber crimes disputes, etc., which was not there earlier. We never even knew about these things when we were doing our law. So, but then that is why it calls for continuing education as well, that there has to be a continuing education, there has to be an education in the new fields, how we grapple with all this. That is the challenge. And if we want to have Viksit Bharat by 2047, you rightly hit on the nail that our legal system needs reforms because of various, I would say, these anomalies or shortcomings in our legal system, which you have mentioned. So we will then take this discussion forward for the legal transformation which is required for Viksit Bharat 2047. First is we have to liberalize and modernize our regulatory system in the country, that which many restrictions extra. And now I'm talking about legal profession. We have to allow foreign law firms, etc. Now, and lawyers who practice in India. There has been a lot of debate in last 30 years about this. Yes, in a few months ago, Bar Council of India has framed the rules, and the government is also now want to do it. Yes, but it can be on the reciprocal basis, etc. Then we have to upgrade legal education standards. In law schools, the curriculum has to be in accordance with what is happening in the world, and not only on social justice, which remains one of the pious objectives, no doubt about it. And as I said, it then calls for continuous training and specialization. The lawyers have to specialize in particular field, and they have to have proper training. And it is not only lawyers, I will say even the judges. And then another important thing is that which we are now feeling in India is that we have earlier lawyers means those who practice in the court only, but lawyers are not only those who are practicing in the court, even those who are in-house counsel and not litigating lawyers, they are counsel. They also are playing important role in this entire system, and therefore we have to encourage and recognize them. and their roles today is changing very, very fast. So that is one aspect. And then coming to institutional reforms, which you said that yes, judicial efficiency and reforms are needed. Here, I would say technology should be brought in. First of all, our judge population ratio is very less. It must be 23, 24 per million. Whereas I think in US it is almost 150 or 160. In UK also 120, 30, and in most of the other countries it is like that. So we are very, very less. So therefore, we have to have more judges and to cope with the areas which we are having. I don't know. And Satwinder, you had mentioned, I think 60 million. I think it is around 45 million or so. But if it has increased from 45 millions also, which was few months ago, and to 60 millions, I'm not sure about this. But then we have to imbibe and introduce technology, as I said, whether it is IT or AI, in our legal system in a big way to make it a facilitator. In various ways, it can be, because it's not a at this stage, in what way it should be done, there can be a very detailed discussion on that, but that is also required. Another thing which I feel is that although we have, as I gave you examples, some of the laws which are international compliant, but when we talk of domestic laws, we know there are many archaic laws. And whether we talk in terms of our freedom and fundamental rights, etc., and whether freedom of speech is impeded because of those laws, or right to life, etc., other things. But then this has been done since 2014. Indian government has this deleted or at least 1400 obsolete acts. But then this still has to go on. Then other thing I would say that lawyers today have, and which is again becoming a matter of concern for the entire world, about the climate change and ESG frameworks, that is environment, this social and governance. So these are the three pillars of ESG in the business. So we have to, in our legal profession, as also to gear up to that. And so these are some of the reforms, I would say, which are needed. And again, the issues of cybersecurity and data protection, we still have to come out with some robust law on this. And we can see from various countries what is happening. And I have seen in various seminars, webinars, etc., where our Indian lawyers have really, those who have domain expertise, have excellent knowledge about it. So it has to be disseminated so that others also learn. And today's webinar, in that sense, I would really appreciate you people that you have come out with the idea. So these are some of the aspects which I feel, and if I may say so at the end, only with end up in 2 sentences, that we have, as far as when legal profession is concerned, on the one hand, our Bharat, where social justice is to be done, it still remains a distant dream, and lawyers have to contribute towards that. And there, even if they have to work, we came out with PILs, etc., on that, and many NGOs formed by the lawyers who are working on that. And even when they are not able to earn, and they are doing their bit insofar as social cause is concerned. On the other hand, with the change and globalization and the economic growth, which requires totally different outlook as far as lawyers are concerned, and they have every right to earn and make earnings in whatever way they can, but by legal and ethical means only. So this is, I think I've taken a bit long, but I wanted to summarize what you asked me in this manner.
Thank you. Thank you so much.
But I think, Chuksab, I must compliment the way Justice Sikri has, elaborated everything. When we talk about the Viksit Bharat, even yesterday, I think we had a seminar of General Council of Associations of India, and we talked at length that how from a 4 trillion economy to a $30 trillion economy in by 2047. Law and economics will go hand in hand, and we have to see, and law becomes a very, very important phase. And when we are talking about the digitalization, I think we have to really think about and remove all those archaic and colonial laws where most of the laws are still on the brick and mortar basis rather than on a digitalization and how we have to do it. That's also a very, very important aspect. And then Justice Sikri also talked about is the infrastructure. I think when we are talking about the pending cases, about 60 million, we must look at it and analyze it. I must be, because in the Supreme Court, Justice Sikri might have done this thing. How many are of the litigation, which I feel the government is the major litigator, right? The second is on the matrimonial cases. And the other things which we are talking about is why not we take judiciary even to tehsil level and the suburban areas rather than at the district levels, and how we can empower the infrastructure and the budgetary support for the government. It's very, very important, which we have to see to it. Over to you, Chuksa.
Mrs. Satwinder, you are right. I only add, and when it comes to struggling or coping with the arrears, there are 4-5 things which I mentioned only one, that is increase in the number of judges. Infrastructure I mentioned, but it has to be now totally, as I said, IT equipped and all that. They have to be proper, and we have to learn from how now as a judge of Singapore International Commercial Court, I know how in a very, very systematic manner and in a scientific manner the cases are dealt with, and we still have to start adopting these practices of case management and court management, on which there have been lots of discussions, but it is not still just to judge at individual level. It is done. Many I have done in when I was judge, but it is not institutionalized so far. It has to be. And then very, very important thing is what you touched about the government. That is what I call, and I have been saying, litigation policy of the government. And we have seen, for various reasons, unnecessarily appeals, etc., are filed by the government, even when I say government, means public sector also is included, because I think 55 to 60% of the cases in India represent government. Government is a party, and those cases can be drastically reduced, because if we go by and only law and economic principle, when the appeals are filed, in how many cases they have succeeded, and even let us take the cases of where the revenue is involved, tax matters, etc., in how many cases they have succeeded, and how much revenue is generated from that in success of those cases, and how much total expenses incurred by the government in fighting all these things. Suppose out of 100 appeals filed in the Supreme Court, 95 was dismissed, and 5 cases which were decided in favor of the government, and the revenue generated from those 5 cases vis-a-vis expenses incurred on 100 cases.
Yes.
See, ultimately, it is realized that there's no gain. So what's the use? And good thing I will say that on papers, the government realizes it. They are coming out with what we call litigation policy and how it is to be done, but it is not implemented. It remains on paper. Other thing here I would add, and Mr. Chandok, when he comes, will allude to it in detail, because I know it is his very favorite subject. That the way success America has had by channelizing it into the mediation. Mediation, when you do this, today 93-94% cases in America are settled through mediation, pre-litigation mediation, court connects mediation, etc. And this COVID has taught us what we are now doing, online discussion. So online disputes, ODR, is coming in a big way in many other countries. Here in India, it was realized, I think, way back in 2001 or so. Niti Aayog, which is like a planning commission, Niti Aayog had set up a committee on ODR, how ODR can be encouraged. And I was incidentally the chairman of that committee. We submitted a report after detailed studies, but then it has also to be implemented. When these things are done, ODR, mediation, and other things, and the workload of, I give you in ODR, I've seen in many various countries in Europe, some in America also, most of the cases which are this what you call consumer disputes. Most of the consumer disputes, which are small scale disputes, can be settled in ODR, and it can be settled within 1 month. And if we see here our pendency that 30-35% cases, or maybe little more cases, would be criminal cases. Out of these criminal cases, maybe 1/3 of this, they are check bouncing cases only. All these check bouncing cases of the banks, which they converted into criminal cases, now they can be settled in ODR. Easily it has been done by others. So if we are successful, 1/3 of the criminal cases go off the court records in one go. I mean, in one shot. And so consumer cases, these which we call 138 negotiables toward the bank check bouncing cases, etc. So we have to see here the Supreme Court should take a lead. Which are the cases which are predominant and can be settled through? We are settling the cases in a big way in Lok Adalats. Month now, when the National Lok Adalat takes place, 2 or 3 million cases are settled. So why not encourage all this? But then what is needed is an all-round effort. It's not only that we pick up one activity, we pick up another field and a third field. It has to be an all-round effort, touching upon all these causes of delay and tackling with them in one. So thank you
so much
for
thank you.
Saying this. So I thought that let me discuss something about this as well. Yeah.
So we'll come back to you for another question. I think NPS. Mr. Chandiok is also here, and I think Sanjeev has joined. So,
Mr. Chawla, if you can introduce Mr. Chandiok, and briefly, of course, a proper introduction of his would take 1 hour. See what you can do in 2 minutes.
I'll do it in 1 minute. It's tough, although Justice Sikri has set the tone to such a level that we are getting this recording also. And we'll post this recording also, as Mr. Chugh has already mentioned. So thank you, Justice Sikri, for your views, elaborative views. Mr. Chandiok also actually needs no introduction. Mr. Chugh is right, it'll take 1 hour, but I'll just say 2 lines. Mr. Chandiok, I call him, he is lawyer of lawyers. He'll always be standing with any lawyer in need, always. He's been 6 times the president, record, 6 times the president of Delhi, elected president of Delhi High Court Bar Association, senior advocate, INSOL India president, president of Bar Association of India, and so on and so forth. One thing where I'm sure Justice Sikri also mentioned, Mr. Chandiok is the propagator of mediation process in India. He's the one who loves to get the matters settled through mediation, and he was also former ASG. And certainly he would comment upon the role of government as to why government litigates. Since Mr. Ghemawat is also here, I'll take this opportunity to introduce him also. Justice Sikri also mentioned about the role and the importance of general counsels and not only the litigating lawyers for the process of nation development and Viksit Bharat, achieving that dream. Dr. Ghemawat himself is an exception, I would say. From a company secretary to becoming a general counsel to becoming a managing director of SR Group. Amazing. His success story deserves to be written in a book, I think. Yesterday, he organized that event where so many lawyers attended, Mr. Chok, in Bharat Mandapam here in Delhi. where he is the founder of General Councils Association of India. And that's the brief introduction about Mr. Chandok and Mr. Gamawat. Over to you, Mr. Chok.
Thank
you, Chavla.
thank
Thank you
you.
very much.
Thank you. Thank you, Mr. Chavla. Welcome, Mr. Chandiok. Welcome, Mr. Gamawat.
Good morning.
Mr. Chandiok, thank you for speaking at the first big, huge event we ever did in our life for Indian Lawyers Association on December 23rd, 2018. And since then, we've been doing an annual event. I think half of the problems of the Indian legal system could have been solved if you had become law minister for a couple of years or even maybe a month. But so all of us, 1.4 billion people, we want to become
Very good
first world.
compliment, sir.
We all want to become a first world nation. We were a first world nation all of our life. Then whatever happened, and we want to become a first world nation. The problem is, I'm sure you would agree that we cannot become a first world nation with a legal system that's not first world. If you look at the judicial world ranking, India is 74, but I have the exact number here. India is 79 out of 142 countries. There are 192 countries in the planet, but this world judicial ranking doesn't measure the bottom 50 or the 50 that don't report. 142 that report, we're 79. So we don't have a problem with Vatican City being the last out of 192 countries because the population is 300,000. But when you subject 1/6 of humanity, 1.4 billion people, to a ranking of 79, then it's a huge problem. And I don't think we can become a first world nation if we don't fix our legal system. Of all the people in the world, I don't need to tell you what the problems are. You know the pending cases and the limited and access of judicial system for the poor, and the judicial vacancies and the corruption and the colonial era laws and the criminal system, the Supreme Court complaining to High Court of Mumbai, why is a bail hearing taking 4 years? On and on and on. So I don't know whose fault it is, the governments or the political parties or the lawyers or the judges or the system. But can you please enlighten us so we can fix our legal system in a hurried manner going forward?
Thank you, Mr. Chuk. It's a pleasure to be amongst you, and especially with you in the midst of us, and with Satwinder being now the president of the Indian chapter. Congratulations to him.
Thank you, sir.
I think we have made a beginning now, because you have made Sawa Lakh as the president of the Association of India. So that itself shows how we are going to take this forward. This is the first point that I want to request you all to please look at. It is always possible for us to look at that there are deficiencies. If we were not imperfect, we would have been gods. There are deficiencies, I'm not disputing that, but look at the way we have come up. Take, for example, to give you an update on two things that I wanted to say. One, that the government has introduced artificial intelligence in Indian courts with respect to petty disputes. In fact, 70, 80 of our judges and ITC officers have already gone to Singapore for a training. Therefore, we will be able to, this is the beginning, to use artificial intelligence with respect to our judicial system. You will find that we will be able to at least able to improve case processing by about 30%. The petty disputes will get decided by what we call robust judges. So traffic challans, all those municipal corporation or other petty situations will be done by them, and therefore all that pendency will go down. One part. The second part is 2025 in Delhi, at least, we have now started, rules have now come in, where in criminal cases, we are now serving through WhatsApp. So these are changes that are coming up. It's not a case that we are standing still like a statue and not moving forward. We are moving forward. And what we dreamt in 2002 by an amendment in the Code of Civil Procedure to bring, as mentioned by Justice Sikri, mediation was brought in as a word in this procedure. But look at the way mediation is taken up today. And I'm proud to tell you that we have 80 cases listed every day in the court annex mediation only, which itself, when people come from outside and visit our center, they feel proud of the fact that they have never heard 80 cases in a mediation center ever in any part of the world. So to say that I'm somewhere else, with all respect, I'm not in agreement with that. And who can be the better person than you, Mr. Chok, that in every law firm of the world, which is of some means, there is an Indian lawyer. That itself shows how much progress we have done. Because without us, even anywhere else, people are not able to work. In 1976, when I went as a professional for the first time to New York, Norton Rosat invited me to stay back. Of course, I could not have, but because my parents were here, my elder brother was here. So I declined that. But not that we have not done progress. We have done wonderfully well. We have today got, as the Sikri mentioned, we have adopted matters. And the only thing which I want the bar to take it up is this. Every lawyer that appears on both sides must sit down beforehand outside the court or earlier and decide that there are 10 issues involved in this matter. And we can resolve all 10, one. If we can't, at least we can resolve 5. We should resolve them. So that much time is saved, cost is saved of the court. Our judicial system requires more honorable judges. There is no doubt about it. If I compare it with my population that I have. But notwithstanding, I should be proud of the fact that a litigant or a disputant of this country still feels in rule of law. And that itself is a big thing. So far our jurisdiction is concerned, you remember that we won in the IBC, which was brought in 2016. We won the first award of the best jurisdiction in the world, beating Singapore even, but 5 years ago. So not that we have not done progress, yes, we are doing it. We will continue to do so. I only request that if I could use the good offices of Justice Sikri, for example, and now Satinder will take up the president to say to the world, to the court or to the Bar Association of India or Bar Council of India, to establish an institute, an academic institute, where lawyers must be trained from time to time. And there should be some regulation by which it should be compulsory for me to go to that institute. We have judges institutes today, academic, where judges go to train for training. Similarly, we need something for lawyers to do, because a common lawyer does not have the domain knowledge of everything that is happening around, development that are taking place. And the senior lawyers must give back what they have earned in their life to the society by volunteering to go to those institutes and tell youngsters what is it. So ethically, that is where you will lift your bar. That is where you will be seeing pendency going round. And I just want to tell you, by way of an example, that I had filed an affidavit in New York court against another cross affidavit, which said it takes 20 years to decide a case. And I showed them examples of Delhi High Court, where we have finished it in 1 year, 1.5 years. So average, for example, today, an award being challenged in Delhi, our system works so well that we have not, some cases may be exceptional, but somebody has died, something else has happened. Otherwise, a 34 petition of setting aside an award or making it confirmatory has not gone beyond 2 years today. That's the way we have traveled now. So to say that we have not done well, we have done well, yes. But I am not saying that we don't need to do more. I need to do more as a bar. I need to stand up today to see what is my first duty. My first duty, as just Sikri rightly mentioned, is to ensure justice. And what you rightly said, how do I reach to the poor? And I want to add to that, we have now started, in fact, on 25th and 26th of this month, we are going to Delhi University to tell students how do they resolve their conflicts. The Delhi University has invited us to do that. So that is the way we are trying to bring about change, but each one of us will have to play a role. I cannot look at only Satinder to play a role, or only the judges have to play a role. And there can't be a better example than Delhi. And if everybody can adopt that, I think we will cross 20-30% decline. There has been a blending of bench and bar in Delhi, which has resulted in what you see in Delhi High Court today as structurally, as by rules, or making dispensation of justice. So these are required to be done. Coming to government, government looks at it. It had a policy in 2014. That policy because the government changed, it was never given effect to litigation policy. They are now coming up with a new policy. I'm sure they are aware of the fact that they should not go in unnecessary litigation. Unfortunately, problem in India is different, sir. Problem is we have a CBI, we have EW. So if as a government officer, I have to take a decision at the time, just 1 week before my retirement, I'll get someone from CBI that you did this. Now, if CBI is stopped and decisions taken by the government officers are not subjected to that harassment, especially when he's superannuating, I'm sure we will do wonders in this country. The talent of this country, there can't be a better example than you, Mr. Chok. A person going from India has done with 500 lawyers at your command in the United States. Can there be a better example than this? So it's not that we don't have talent. It's not that we don't have passion. It is not that we don't have commitment. We have everything. It's just that we need to channelize it in the proper direction. We must lay down paths for our youngsters to follow. We must uphold the traditions of this country to see how do we go back to people. So if I reach out to people and catch them young is the theme that we adopt. Therefore, going to schools, going to colleges, we are developing those children to see how disputes resolution can be brought about. And there are times I have seen by my experience, Justice Sikri is here, fortunately for me, who has himself gone to the mediation centers and stayed there to examine how do we do mediation. It was just nothing to do with, otherwise it's a confidential situation. What I'm trying to say is that we all need to put in our resources. I cannot depend upon the government. I cannot depend upon one bar association. I can't depend upon this. And once a president of an association is elected, then it's my duty as a lawyer, notwithstanding that I didn't vote for him or support him, I must support him in his endeavor, whenever it is required to do something good for the bench and the bar. The first thing that we need to do is the Bar Council of India must change the curriculum in the law schools. It must update its curriculum. And my travel in the last few months today tells me that each state or each university is having its own curriculum. Though maybe fundamentally it may be the same. Therefore, why can't there be uniformity? Therefore, they should bring uniformity in it, reduce the number of law schools, but upgrade their education level, their infrastructure, so that you are able to get the best. There's no teachers' academy today. There's no professors' academy today. We need to establish that so that lawyers and professors go together to teach children in our law schools. That's the important part. I have seen Justice Sikri going to MIT off and on to speak. Why? The reason was from his practical point of view, from his judge's point of view, from a lawyer's point of view, he is able to convey to that youngster what is his future. Time has gone now when a lawyer had only an option coming law faculty, he can only go to court. No. Today there are absolutely different options he has. He can be a general counsel, he can join law firm, he can go many places. The invitation is open today. Notwithstanding that, we need to come together. This is the only problem in this country. That I have to forget the word I and adopt the word of the Constitution, we the people. If we adopt that, I think we can make a progress which no other country can make in this world. But notwithstanding this deficiency, Choksa, I am sure 2047, we shall be a world power. From 79, we'll be probably at 9 at that time with our legal system adopted. Thank you very much.
Thank you so much. From your mouth to God's ears, and to all the people in India that are responsible to fix the legal system. Speaking of which, Mr. Gemawat, you probably most ideally suited to fix the legal system of India. You have a law degree, you have a LLM, you have a PhD in insider trading, you're a chartered accountant, you're a company secretary, you are an advocate, you are a financial controller, you're a head tax, head legal, group legal counsel, and managing director. Why can't you fix the legal system of India? And we had our political freedom in 47, economic freedom in 91. Why can't the lawyers get together and take charge of the country? And the next revolution for us to become a first world nation must come from us lawyers. We need to run the cities and the districts and the states and the country. And if you're made law minister for 1 year and you're given a mandate that Mr. Chandiok said, that by 2047 we need to be 9. But in 1 year, can you at least get from 79 to 59? What would you do? And you only have 1 year.
Thank you very much for inviting me, sir, and for inviting me and for you sharing my views. It's always pleasure listening to Justice Tikri. Always very, very innovative thoughts and absolutely, thought-provoking, views which we listen Justice Tikri and Justice Chandiok.
Mr. Gemawat, if you can get a little bit closer to your computer, we could hear you better. Thank
Is
you.
it fine now?
Yes.
Yeah, a little bit finer.
Yeah. So it's always, good listening to Justice Tikri and Mr. Chandiok, very innovative and thought-provoking views. Navneet, just coming to your basic issue that what to change. I think the moment we keep our objectives clear, things would be clear. When we talk about the aspiration, as Justice Tikri also mentioned in his opening remarks, and Chandiok also, when we are talking about the economic growth, we are talking about $30 to $35 trillion economy and all that. Yes, the basic legal ecosystem needs to change. But then why this would be required to change? And I think that the basic philosophy and whatever developments happen in the last 70 years, I think the basic philosophy should be we need to realize, we need to acknowledge that businesses or the entrepreneurs or the wealth creators, they are doing all this for the economic growth, and this economic growth is not in isolation. This economic growth is for the society, for the people, because this economic growth generates employment. This economic growth gives us prosperity. And the moment you realize that these wealth creators need to be respected, you will realize that your legal and regulatory ecosystem needs to be strengthened. And how they would be respected. And it's very, very basic, Navneet. If a wealth creator is making an investment, he is looking for protection and preservation of his investment. He is looking for ease of doing business. He is looking for certainty in terms of that legal regulatory framework. This is what the basics he is looking for. And the moment you put these basics in place, the things would be fine. There are two aspects of this legal regulatory ecosystem. One is a framework where the entrepreneurs and the wealth creators can do business properly without any, difficulties, and allow them to do this and bring in more and more economic prosperity and economic growth. Give them that freedom. Of course, within those checks and balances. And the other part is on the justice delivery system, which is basically what they are looking for. They are looking for very, very simplistic thing, Navneet, that yes, my costs on litigation should be minimum. I should get the lesser time justice should be delivered to me. He is looking for certainty. Whatever the judgment comes, they should be certain and they should be enforceable. He's looking for very basics. But we have not been able to provide these basics despite of the government being very, very proactive in terms of coming out with one or the other reforms. And in the last 10 years, particularly, when we talk about, I think government has been very, very proactive, whether that be in terms of reforms on IBC or reforms in terms of the transparency and procedural law related issues and so on. But still, we are 163rd in terms of enforcement of contract. And why we are 163rd in enforcement of contract? I think the whole legal ecosystem needs to be changing there. Now, the Justice Tikri did mention about that, and when we say that what changes are required, the changes are required that we need to understand and appreciate that whether with these kind of laws which have been enacted 10 years back, 50 years back, we are still continuing with the same legal framework. Can we continue for the next level of growth in terms of $30-35 trillion we are talking about, which economy is largely based on technology and innovation. Are these laws sufficient to cater to that kind of needs? I think that we will have to ask ourselves and support the government, support this legal ecosystem in terms of giving our views and counter views on this. Similarly, as regards this legal ecosystem is concerned, we were talking about, and I have been speaking on this subject for the last 10 years. But every year, the number of cases which are pending in the courts are increasing. They are not getting diminished. But then have we found the solution? We have not found the solution. Can we use some other models which have been applied in other parts of the world? We should consider that. If we can come out with some solution, let's do this. And just for your example, in UK, also there was a similar position in terms of pendency of cases, in terms of the time which it takes in terms of resolving disputes and all that. And there were two major reforms which happened. I feel that they were very innovative. Those reforms were one was from the Wolf Committee, I think 99, and another was on the Jackson reforms in 2013. What they did very simple thing. They said that okay, this is a tendency of cases. Why not to involve the senior advocates? They can be there as a judge for a limited period of time. They can be just for a say, 1 year, 2 year, 3 years period of time, and those pending cases can be resolved. This is a very simple solution. We have so many of senior advocates all across the country. Can we use that model? The answer is yes. And the one biggest drawback, Navneetji, which it appears to me, litigation is a hobby in India. We keep on filing litigation under one pretext or the other without realizing that how much it is costing the economy or it is taxing the economy. Now, one reason which I find and where there is a solution in my view is that there is no fear in terms of filing frivolous litigation. Can you create that fear? Forms which have been done in the UK, for example, through this Jackson Committee or the Wolf Committee also, the cost recovery part of it. If suppose somebody is losing a case, there should be some effective recovery process. And the process is so smooth there in terms of even in the first procedural order, they come out with the whole structure. And they are very clear that this would be the cost structure which would be applied from the litigation process. Can that be applied here? Answer is yes. Would that be creating a fear amongst the people who are filing frivolous litigation that ultimately they will have to pay that cost? Answer is yes. Can we reduce the litigation through this process? Answer is yes. The third thing which appears to me as a solution again is that, and I think Mr. Chandyok and Justice Sikri also touched upon that use of technologies, use of AI. Now just look at it. Out of 5 crore cases, we would be somewhere around 30% or 40% of those cases in terms of very, very simplistic issues on check bouncing, for example. And that to be streamlined through this technology process? Answer is yes. So is the government cases where the government is filing cases, can the AI be used in terms of reducing that backlog? Answer is yes. Just think about it, that in a of the consumer cases in any industry, there would be around 10 kinds of cases, 10 or 15 kinds of cases where that would be related to deficiency of service or the product is wrong. There are 8 to 10 classifications or 10 to 15 classifications. Can AI be used that in these kind of situations, precedent has already been set, the law is already set, and if you want to issue this case, then you will be liable for that cost. You will be liable for indemnity. Now, can you be using this technology and reduce the backlog of cases? Answer is yes. For all government filings, if you have a mandatory process of checking through the AI models that these cases will get filed because of the precedents and because of the law, you would be losing these cases. And still, if you want to file this, there should be responsibility, should be fixed with the concerned official. The moment you apply this, at least the checks and balances would be there. And also that this fear that some vigilance or the CBI or some investigating officer would be investigating my case, I think that can also be taken away. The moment you do this, the backlog of cases can get reduced. So I think there are multiple ways of addressing this. The only thing is that the deliberations are required. A public opinion needs to be framed. And once you frame the public opinion, I'm sure government is very proactive and some changes can be brought in. Yesterday we were having a a conference on legal reforms on it was reimagining the legal ecosystem for India at 2047. Just was facing that event. And Justice Sikri was also giving his amazing thoughts, for example, on various issues. And one of the issues he touched upon is very I'm very passionate about it. That issue is on law and damage. Now on the commercial cases which are pending in the are the determination of damage. Now here is a situation: two mature parties, large business groups, large business entities, with all commercial and legal wisdom and with all legal support entering into a contract, and they agree that if I breach this contract, I should be liable for this much of amount. Now, what for, why for litigation is required for that kind of commercial contract? I don't see any reason. I don't see any rationale. We are not in 100 years back kind of society where the relationship was between a landlord and tenant. Landlord, the kind of contract which he writes, or the sahukar, or the, those kind of general farmers, whatever you write, you will be liable for that. We are not in that society anymore.
So, Mr. Kiwawat, about 25 years ago, on Harvard Business Review, last page, there was an article by a CEO, and he wrote that when I have a lawsuit of a big nature, I ask my law firm that give me the best lawyer you have. Then I meet with the best lawyer they give me and talk to them about litigation. Then when I'm done, I call the managing partner of the law firm and say, give me another lawyer, your number 2 or number 3 or top 5. And the managing partner says, why do you need a second lawyer? He says, just send one. So the second lawyer comes and he says to the second lawyer, I have hired John, the first lawyer, to handle the case. I need for you to settle this case. And I'm hiring you separately, and you're not interfere in what John is doing or be persuaded by John. I need for you to settle this case. And so a lot of our clients, for instance, a lot of countries, developed nations have laws that cases must finish within 3 years or 4 years or 5 years. Otherwise, they're dismissed in favor of the defendant with prejudice. Denmark, when you file a lawsuit, you get a trial date 90 days from that day. And the court is like, why are you filing a lawsuit if you're not prepared to go to trial? Justice Sikri is right. 95% of cases in a country like the US finish within a year and a half. There are laws over 5 years, it's thrown out. The oldest case in India is from 1878, the Varanasi dispute of 2 acres. But what I wanted to say all this to you, there's a reason that you have a lot of power as general counsel and as managing director. A few years ago, I was speaking to a judge in Rajasthan, and he's very famous that he reads every page and goes over every matter. And I said, why do you do so much? And he says, well, I like reading everything. And you know how much Indians write. And I said, what do you mean how much Indians write? Aren't there page limits on pleadings? He says, what do you mean page limit? I said, there's page limits throughout the developed nations. The secret of life is cut, copy, paste. And we don't have to reinvent the wheel. It's been invented. And he says, are you serious that there is a page limit on pleading in court procedures and law? I said, of course there is. For criminal is this much, for civil is this much, for divorces is this much. 5 pages, 10 pages. Appeal courts have 70,000 word limit. One extra word. On front of the appeal brief, you have to certify that I hereby certify that it's less than 70,000 words. One extra word, and you know the court's going to check. One extra word, the appeal's thrown out, returned to you. And the appeal has to be filed within 60 days. And if you miss out on time, good luck. No excuse whatsoever. So I said all this to the judge, and he says to me, this is very hard for me to believe. How is justice happening? I said, if justice is happening in 400 pages, it can happen in 40. There's nothing you can't write in 40 pages that requires 400. So he says, send it to me. And I'm like, okay. And I, of course, don't send. I thought he'd get offended. Yeah, again, sale foreigners telling us what to do. I didn't send. A week later, WhatsApp message, Mr. Chuk, where are the laws? The page limit laws. So I sent him everything. State court, county court, federal courts, Supreme Court, everything. But as general counsel, you have so much power to fix the legal system. Tell your lawyers you're hiring, any pleading over 10 pages, I'm not going to pay for it. And if you write 17 pages, my accounting department is instructed to remove 7 out of 17 percentage, 40% we're not going to pay. Also tell your lawyers that I'm giving you this case not to fight, to resolve. I need this settled. 3 months, 6 months, 4 months. And I'm going to only agree to settlement mediation if it happens in consecutive days, not 6 months later, not 1 year later. That's just sheer waste of time. But I thought I can't resist because I feel that the general counsels of India can change the entire legal system.
Navneet, let me add one thing here. You have mentioned, because of course your comments are absolutely to the point and aimed at general counsel. But let me now say something to Mr. Amarjeet, Jok and Satwinder, etc., and Chawla, as far as lawyers are concerned. We have to set time limits even for arguments in the court.
Yes.
And you see, this is very, very necessary. I know in Supreme Court, US Supreme Court, 30 minutes argument. And they are so strict about it. If judge has asked a question, and it's a judge who has asked the question, and the lawyer is replying, and 30 minutes have finished. So he's not even permitted to complete his reply when he's answering the judge's question. So they are that strict. And here I always use Amartya Sen's that title of the book, Argumentative Indian. So we go on and on and on. I tell many times when I go to law schools in their these moot court competitions, I said that one thing from you students, which the lawyers should learn, is that in this 40 minutes, moot, which you are allotted to you, and very complex problems with so much of case law, you are able to finish in 40 minutes. You are able to convey the message. So while lawyers are not in a position to convey the message, and what I said initially about this court case management, etc., I have seen in international arbitrations also, in my SICC Singapore also. What happens is that before the hearing, the lawyers are asked how much time you are going to take for arguments in this matter. Whether it is in arbitration, it will be evidentiary hearing also, followed by arguments. And of course, in arbitration, both are given equal time, but they discuss among themselves, because another important thing which Mr. Gemawat has said, Dr. Gemawat has said, is about the cost. So they won't take unnecessarily even 2 minutes more, because they know that clock is ticking when it comes to cost. And likewise in SICC, my Singapore court where I sit, I see there also before the hearing, CMC, which we call court case management conference, which takes place, and the parties tell how much time they are going to take, both the sides, and then they stick to that timing. Not as 1 minute, not even 1 minute more. I think that discipline is required in our courts also.
So
on your question of this thing, this issue I raised at one point of time with Justice Sikri. Sir, how do you read so plethora of all the documents with number of pages and all that? So he said that, Satwinder, no, we have developed up not the horizontal reading, but a vertical reading for this. I still remember that he said, I know that vertically where the problem lies. And I was having a discussion with Justice Mukhopadhyay at one point of time. He said that, okay, if you have 8 grounds, I will feel that, okay, you don't have any case in appeal. But if you have 2 grounds, I will see it's a reasonable case. But if you have only one ground, I will say you have a case.
But I want to just
So-
mention one thing here.
So I just implement. Yeah, no, sorry. I was just appreciating of my experience when I visited your country, because you are now in the US. I had the pleasure of attending a hearing in Massachusetts, Boston, and the entire case we won there, and we used that in India as well. Is the transcript, and I think I mentioned it to Mr. Chandok earlier. Unfortunately, didn't got the opportunity to mention it to Justice Sikri, that the system which they follow there, which I think one of the CJIs recently introduced in India also in Supreme Court, but that's yet to be followed. The system of getting a argument, getting a written transcript of the arguments. The difficulty is not only of the time limit which the lawyers take. The difficulty is also of the change of the stance of the lawyers. One lawyer arguing something, and next hearing, lawyer would change, the argument would change, and so on, it will continue. But there in US, when it was argued, the transcript was used by us of the US court in India also to win that case ultimately. Mr. Chuk.
Wonderful. So we have
So-
a few minutes left. I have one question each more of Justice Sikri, Dr. Gamawat, and Mrs. Chandyok. But Dr. Gamawat, you were saying something, please.
No, I was just trying to mention that, our approach when we handle the international arbitration or, litigations in foreign courts, our approach is very, very different. Because there the discipline is coming from the bench, and the bar is also following the discipline. It's against this
So,
in India.
so Justice Sikri, a horse runs faster when there's another horse running next to it. One of the advantages of having a big country like ours is that we have 29 states. And if one state is doing something good, then the other states nearby or somewhere else far away can copy. The question I have of you is, do you think that the states of India should be given more power and freedom to run the judicial system in their state so that at least a few states get their act together and reduce the pendency of cases in their state, and then maybe other states can copy? Why is everything run from New Delhi?
Yeah, Mr. Chug, I think the question is very relevant. If we go by our constitutional system, the states have the power under the constitution up to the High Court. I mean, of course, it's although we have federal structure, but which is more centric in the sense the power of the center is more. But not that under the constitution, High Courts don't have the power. But over a period of time, the way it is done, I have seen many times even the now states look forward to only the center or the even the high courts look forward to the Supreme Court what should be done. But having said that, and I include Delhi High Court also, have really while managing their courts have come out with the outstanding reforms with the active support of the government in those, because here when it comes to reforms in the state in whatever form in all these areas which we have discussed, it has to be a cooperative measure between the state government as well as the judiciary to that extent. Because first lies with the government in any case, as we know, and many reforms in the form of legislations where the state can pass, of course they would have that limitation that we have in the 7th schedule. The 3 lists are there. So the state legislature can legislate only on list 2, and of course concurrent jurisdiction on list 3. Not that what is mentioned in state list 1, which is the forte of the the parliament. But within that, I agree with you that state should be. They rather I would say they have the power. They should exercise that power. Many states have done that, and it is followed by others. But many times it is said that, okay, it may be because of the peculiar local conditions of that state, which may not be possible to emulate in other states. Those are the different things. But your suggestion is well taken, and I feel that, yes, it should be done.
Just quickly, I have only one point. The thing is, is language an issue? Why not we can have, you see, at the, as I said, that even at the sea level and not even the district, but down the line, the judicial system in the local languages, so that
You see, I tell you, Mr. Satwinder, this problem should not be there. It's already, getting diluted with AI. Now, we are speaking here. If AI is there, anybody in any other language would be as if it's not even to be, we don't even need the translator who is translating at the same time in other language. With AI, everybody would be listening in his own language. So likewise, once this AI is introduced and with full measure, so all this language problem would be solved. You are speaking to me, and if I am using AI, I am listening in Hindi, whatever you are speaking, or I am listening in Tamil. So that's the beauty of AI, which has to be introduced.
So that's where we are saying that the best part is that, okay, if we are looking at Viksit Bharat, I think the technology absorption is.
Yeah, it was. You remember 2 years ago, 2.5 years ago, Indian Supreme Court has said that yes, the judgment should be translated and all that, and which is happening. But with AI, this would be a thing of past. We don't even require that kind of services now. It would be automatically provided.
Yeah. So, Mr. Chandriyok, before you joined, I was saying that the lawyers got India independence, but then everybody else got free except for the lawyers. And the 1.5 million lawyers are the only people in India that are not free. We cannot advertise. We can't have a booth at a conference. We cannot have a website. We cannot take matters on a contingency basis. We can't teach without surrendering our law license. Now, the question I have is, the purpose of law is to protect the powerless and the poor from the rich and the powerful and the government. The only way the poor have access to justice is through contingency success fee lawyering and information. So now both are banned. You cannot advertise. You can't tell to the poor people that, hey, you have these rights, and if these rights are being violated, come to me. We will take care of it, and you don't have to pay. We will, when we collect, we'll give you a percentage. The worst statistic about India that I've ever heard is that there's 1.4 billion people, 900 million people of working age, and on official payroll, it's only 60 million. Only 7% of the country is on official payroll. We can't become a first world nation till that number is at least 80%. So my question to you is, why can't the lawyers fight on this restraint of trade 19? And why can't we fight and let us do our websites without conditions and advertise and take matters on contingency basis?
Let me put it across that I think in way back in 2012, if I'm not wrong in my year, we submitted a report where we did not say advertisement in websites, etc. Of course, we said you can have directories published of every bar association, which would have our names and provide our CVs in a limited way, so that anybody can have access to that and to know where to go and to which lawyer to engage. But having said that, if I'm opening the international market to lawyers to India, this is the first thing that we'll have to do. We have to compete with them, then you need to advertise, allow us to advertise also. But advertisement also has repercussions, because many times I make out as if I am the God, whether I don't even know the spellings of God. That is the problem of this country. Therefore, while I accept that we need to build up as a bar to say that we should at least be able to be available on public domain, people should be able to judge us for that part, but we have to understand how do we regulate it is the question. Because self-regulation has failed. Let me be honest on that. We are self-regulated by Bar Council. We have failed on that front. I must accept that part. But the question is, why am I not teaching that youngster how to bring his self-regulation back? Why are we not, I was just saying, the secret will bear me out. We have now adopted the system advance copy. So he gave a hearing at the first advance copy when I served on Mr. Chawla. Then he filed the reply, give another hearing. Then once he done, everything is done, then the third hearing. So at least we can avoid that. I remember when I came to the bar, if I gave one point to the Honorable Judge, the entire order was consequential, whether he gave me 100% or 50%. So we need to change those reforms back. We need to look at that. And therefore, the question is, yes, bar must get that right to advertise, not in the manner in which US does. Because I remember even now when I went to GEMS International, I was there in the institute in San Francisco. I saw roads saying abuse of law, abuse of court process. So these are processes which we should also learn from that. But yes, we should be allowed to make our directories where we should know what kind of things that we do, so that people should approach me if they agree to that, doing that. And I think it should be made compulsory for us that if you are doing 100 matters a month, you must at least do 20 matters pro bono. Not pro bono, what we saw in US. I see lawyers saying I'm pro bono, and then there's an agreement between him and the client that once you recover, you will pay me back. That's not pro bono. Pro bono means pro bono. Therefore, contingency is correct position. In this country, problem is we get a problem, we get something, one in hand, we try to misuse it. So that misuse at a district level especially, I need to watch out. That's my problem here. But I still suggest, yes, time has come that we should be able to demonstrate some kind of information to the public. What am I doing? What am I capable of doing? And I must tell you, Chuk Saab, in this country, reputation moves much faster. Not that just Sikri is here that I'm saying it to you. If I was an arbitrator nominee of a party and there was somebody else, I would only suggest his name because nobody will dispute that part. That he'll be with the presiding arbitrator. Though I've not got a reciprocal from him, but that's a different matter.
I'll keep that in mind.
Dr. Gimawat,
responsible.
the last question goes. Yeah, thank you, Mr. Chandiok, very well spoken. And I think if somebody is saying something wrong in the advertisement, then that's okay. It's freedom of speech. What about all the other businesses? They lie in their advertising all the time. Why are we subjected to a higher standard? And then there's bar council. They should. Because
my profession demands higher. That's the difficulty.
Yes.
The Sikri said.
So I'm just looking
my
at
comment on this particular issue is Satvinder ji, and as Mr. Chandiok was mentioning about that, code of conduct. Here is a population of lawyers who are controlling or who are doing the legal issues of 60 or 70% GDP of India. They are not under the umbrella of any professional institution or a code of conduct. I think that is the correction which we need to do. And that's the reason we are talking about that we let the general counsels who are part of this profession acknowledge that they are the lawyers. What we
So I have a last question for you, but before that, Satvinder, go ahead.
No, I was just looking at it. Is what is your thought? At least what Mr. Chandiok said, even Justice Sikri, I was looking at it is, as regard the dissemination of information that what you have done, at least we should have something on the website and all that, which we can just put it, because where there is a technology which we are talking. Chandiok sir?
Right.
That's what I'm saying. We say that I have done these matters. These are the judgments pronounced. Whether you have lost it or you have won, that information is still possible. But you know what happens in today, what we are doing also. Law firms are not allowed, but you know how many foreign law firms work in India even today. Delhi itself must be having 40 law firms, foreign law firms working. Now, how do we abuse that part is to be checked is the question. And that, Satvinder, nobody can do. I, as a professional, must stand up to these ethics that I need to adopt.
So, Dr. Gimawat, we have our session today on YouTube Live and Facebook and LinkedIn. So there's a lot of other people that are watching. We have one question. I'm sorry, we're running short of time. We said we'd finish at noon. We've gone a little over, but last question to you. So this question is from a young lawyer, and he or she says that there's 1.5 million lawyers in India. I want to be in the top 1% in the country, in the top 15,000. Ask Dr. Gimawat, given everything you said he's done in life, and all his education. He's a lot of lawyers and met with a lot of lawyers. What does he look for when he finds an outside counsel? What are the characteristics of a good lawyer? And he wants to become one. And he wants to know what are the top 3 or 4 qualities that he should work towards obtaining.
I have a very simple answer to this. It's just the 3 words. Keep on learning, relearning, and relearning. And keep doing this. All other things would automatically fall in place.
Do you have one thing, Mr. Chandiok?
I have only one thing to say, his passion, his commitment. And I can only give you an example. When I joined the bar, my senior gave me a file in my hand and a CPC said, "You're no longer a Sardar from today." So I thought I didn't come to change my religion. So what he said was, this brief is your place of worship. Be responsible to this brief. If you're responsible to this brief, you're doing actually worship because you're getting justice to your client. So I think that aim he adopts, he should be in that. Why 15? He'll be first 5.
One comment, Satwinder, one skill, what do you want this young lawyer to learn?
No, I think what Sanjeev has said and Amarjit, and this was the topic which we have taken it. And I always say is, you see, when you started with this thing that how the lawyers can be enriched monetarily, and I said I started with this thing because I'm of the firm belief, one, that there is no substitute of hard work. Second is, I always putting it that Saraswati and Lakshmi never comes together. And if you have a blessings of Saraswati and you're doing it ethically, Lakshmi will always follow. And this is what I'm just looking at. It is where we talk about all this thing is that first you get enriched academically, work it on ethically, and just think about the money will come automatically. That's, I think, it has come to me as a blessings. I will always say that from where I've grown and where we are, and the guidance which Justice Sikri and Chandiok have given to me. And today, whatever I'm today is only because they handhold. And this is what the legacy we have to carry.
Satwinder, we want to become a first world nation by 2047. Money needs to come first. Mr. Chawla, your sentence.
I would say, after and not repeating what has already been said, in addition to that, I would say anticipate, and anticipate. So anticipate first what your client actually needs, and then anticipate how you can get that relief, what the judge would ask you, what the other side would argue, and then anticipate that if you fail, then what's the backup plan. So those 3 anticipations would really help us a lot, being a lawyer.
Justice Sikri, you started and you get the last word.
No, thank you. I think I'll echo what is already said, and my message to that young lawyer would be, and I give you one anecdote. As while narrating my CV, in that sense, Mr. Chawla mentioned I was topper in law. When I joined profession, on the very first day, because my father was also a lawyer, he handed me book of Mr. Seetalwad, his autobiography. And he said that read it. But then he said that you will read it at your leisure. But then he showed me one paragraph in that book. And he said that read this message, which I want to convey. Is that, and I still remember the sentence, it was, you may be a topper, you may be a gold medalist in law. If you can't work hard, please don't join this profession. And this legal profession is your jealous mistress. It is the first mistress. I mean, this is a profession which would need more time. And I remember another anecdote, let me share with you, which was one lawyer, very prominent lawyer. He said once, maybe, I heard it almost 30 years ago at that time, that in this profession, it is not the number of years you put in which matters. What matters is how many hours and minutes in those years you have put in. So therefore, there may be one lawyer with 20 years standing. He may not have worked that hard. Another lawyer with 10 years standing may have put in more number of hours and minutes. So he will shine. better than the other. So therefore, hard work, which everybody is saying, one very, very important thing, and keep learning. And I would only add with and this end up with this, that look, many I have seen today, and you also said about, yes, earning of money is important. Anybody who joins any profession, any vocation, etc., is ultimately for earning money. But you should not just look to money first. Satwinder and Chawla have given that example of Lakshmi and Saraswati. In that beautiful manner, they have captured that. Yes, you should try to. When we were, youngsters and we had joined, we were, whether our senior was giving any money or not, we never bothered. And even if he was, I remember the first fee I got was from my senior. He said that do this. It was a written statement which was to be drafted. After I drafted that, he gave me 55 rupees. I still remember. So, and I was so thrilled. Oh, today I got, because it was fifth or sixth day of my profession. Oh, I've got this much money. So therefore, money would come later automatically. It will follow. You do work with commitment, and keeping in mind all ethical practices. You don't have to cross that line, that Lakshman Rekha, just to earn money.
Thank you, thank you, thank you so much, all of you, for giving us your time. We learned a lot. We hope we can bother you again and have you join us again. President Satwinder, congratulations, all yours.
Thank you. I think at the outset, let me offer my huge gratitude to Justice Sikri, Mr. Chandyok, and Sanjeev Gamawat, just on a phone call. When I said that, okay, we are hosting a program, and Navjit said that, okay, we have nominated you to be a president. And I said that without their blessings, I will feel that, okay, I'm missing something. And they immediately accepted it. And I think, thank you, Justice Sikri. Thank you, Chindok Saab. Thank you, Sanjeev, for and thanks to Chuksa for, bestowing me this responsibility. And I assure you that the way the aims and objectives of ILA have been made to enrich the lawyers and hold programs, I have taken it that, okay, how we can take that benefits. I've already started discussions where lawyers can be even offered certain benefits through continuous engagement. And when we, just talked about the academic enrichment, which we just talked about, be it the matrimonial issues, be it this thing where we are seeing pendency of the cases. The quality of education is very, very important, which we are just looking at it is. And I still remember the words that the best lawyers are rarely only lawyers. They are part of economists when you are talking about the commercial matters. They are part psychologists and part diplomat. That's when we are talking about the mediation, sometimes you have to have the diplomacy also. When you are handling the matters and most of the matters can be sorted out through mediation, and where you have to learn the traits, or to, even understand the psyche of the people and other thing, and to make it. And this is the important aspect which we are saying is, and what I've seen is that, in other professions, be it a doctor's profession, be it the pilots, be it even the company secretaries where I was deeply involved, and the Institute of Chartered Accountants, there is a concept of a continuous legal and mandatory. They have been given the, mandatory hours. They have to, spend those hours in the legal education, the continuous legal knowledge they have to gain it. I think somehow I am missing that, okay, such programs the bar should see, and the law should not see it as a burden, when maybe the bar should impose as a mandatory aspect to this, and the professional pride. That's the important. And on the ethical part, where I'm just making it is the it reminded that the true function of a lawyer is to unite parties. That Mahatma Gandhi had said at one point of time, who are splitted and at least give a best try. So we need to look at it that, okay, what would be the best and the real solutions through settlement, mediation, or interplay. And I remember that Abraham Lincoln, timeless counsel, if you cannot be an honest lawyer, resolve to be honest without being a lawyer. So that's where I'm just only on the, and I still believe that uh, academic enrichment keeps our mind sharp. Ethical enrichment keeps our profession noble, because we always says that the lawyers have a noble profession, and monetary enrichment keeps our work sustainable, and we have to work on all these three goals. With this, once again, thank you so much, and we'll keep continuing with the monthly sessions. And I will come back to you, and I'll need your mentorship. I need your guidance, how we can work it on the different topics. We'll call the experts and make it every third Thursday. We should hold one program. That is the motto, which, and I'll take guidance from you. Thank you so much.
Thank you, Satwinder. The 165,000 lawyers of Delhi, they want to learn, they want to be noble, they want to be honest, they want to be ethical, but they need their handcuffs removed, and they want to make double the money they're making now in 3 years, and every 3 years they want their money doubled. But the biggest reason for ILA is freedom of speech and no restraint on trade. Please remove the handcuffs. One fine day, the government of India is going to allow foreign lawyers to come in. And that's not fair, because that's kabaddi match. Our hands are tied and have been tied for 78 years. Remove the handcuffs. Then we'll see what we can do. Then let foreign lawyers in. Thank you, thank
Sure.
you, thank you all
Yeah.
for joining us. We're grateful.
Thank you.
Thank
Thank
you.
you.
Thank you, sir. Thank you.
Thank you.
Thank you, everybody. Thank you so much.
Thank you. Thank you, Satwinder. Thank you, NPS.
Thank you, everybody. Ji. Thank you,
Thank you,
everyone.
sir. Thank you, sir.
Thank you.
Thank you.